Ladies and gentlemen, the event will now begin. Kelly, please go ahead.
Hello, everyone. My name is Kelly Nash, and welcome to today's webcast, Arbitration and Mediation in the Workplace, Important Considerations for an ADR Program. This event is brought to you by National Arbitration and Mediation and sponsored by Law.com. Before we begin, I'd like to go over some basic housekeeping items to help you use the webcast console throughout this hour. First, this event is completely interactive and incorporates many of today's social media tools. You can tweet or directly post information to your Facebook and LinkedIn pages right from the console without having to open a new browser. Just scroll along the bottom of your screen and click on the social networking widget of your choice. If you have a question for one of our speakers here today, please enter it in the Q&A widget on your console. We will get to your question during the live Q&A at the end, and we'll answer as many questions as possible, so please feel free to ask away. And if we don't get to your question within the hour, we will do our best to follow up with you after today's event. In addition, there are some other customizable functions to be aware of. Every window you currently see, from the slide window to the Q&A panel, can either be enlarged or collapsed. So if you'd like to change the look and feel of your console, please go right ahead. Also, this event is CLE eligible. CLE has been approved in the states of California, Illinois, New Jersey, and New York only. CLE credit is available for attorneys in the approved jurisdictions, provided that you have viewed this event live for 50 minutes or more. Participants who wish to receive credits for other states must check directly with their CLE board. Within an hour after the presentation, all attendees will receive further instruction via email on how to obtain your CLE. The CLE code will be announced during the presentation. New Jersey and New York attorneys should be sure to retain the code for their records, since they will need to re-enter it in order to download the CLE certificate. The certificate will be available for download 1 week after the event on September 24th. And now for today's topic and the reason you are all here. Employers and employees may face workplace disputes involving an array of matter types. There are many important reasons why an employer might choose to implement an arbitration program in the workplace. Alternative dispute resolution methods, like arbitration and mediation, are often used to reduce the uncertainty and expenses of litigation and can help reduce and resolve business and employment disputes. We have an expert panel with us here today to address this topic. First, we have the Honorable Judge Peter Skelos. Judge Skelos' career includes 11 years spent as an Associate Justice of the Appellate Division of the New York State Supreme Court, 2nd Judicial Department, where he served until his retirement in 2015. Judge Skelos' judicial career began in 1995 when he was elected to the District Court, Nassau County. In 2019, for the 4th consecutive year, he was voted a top 10 neutral in the New York Law Journal Best of survey. Also in 2018, he was named a National Law Journal Alternative Dispute Resolution Champion. We also have with us Rhonda Epstein. Rhonda is a seasoned litigator with over 35 years of wide-ranging experience in civil litigation. She concentrates her legal practice primarily in the areas of employment law and housing discrimination. Rhonda is also experienced in various matters, including the directors and officers of cooperatives and condominiums, their board of directors, and property managers. Next, we have David Feather. David has been engaged in the practice of law for nearly 25 years and is a seasoned litigator. He has focused his legal practice on labor and employment law matters. Representing both employees and employers in management, he practices in both the state and federal courts and regularly appears before the Equal Employment Opportunity Commission, the New York State Division of Human Rights, and the United States and New York State Departments of Labor. And last but certainly not least, we have Jacqueline Silvey. Jacqueline is General Counsel of National Arbitration and Mediation. She is involved in various management operations of the company, including panel development, oversight and implementation of commercial and employment dispute resolution initiatives, the creation and implementation of various rules of procedure, and the general business affairs of the company. Jacqueline joined NAM in 2007, as staff counsel. So a very warm welcome to all of our panelists here today. It's great to have you all for what I'm sure will be a very informative discussion. Without further ado, I'll go ahead and turn it over to Judge Skelos to get us started.
Thank you, Kelly. Appreciate that introduction, and welcome everyone to our program this afternoon. We hope that you'll find it useful. We'll be toggling down the slides and toggling also back and forth between presenters. This afternoon, our first presenter is Rhonda Epstein. And Rhonda, I'm going to ask you to speak to the venues in which mediation is being used in the employment dispute context, and also to address some of the issues or the reasons people should pursue mediation in the employment context. Rhonda?
Hi, everyone. So mediation has been around for at least 30 years officially. When the EEOC started its pilot program and it formalized it officially in 1995. It's widely recognized as a reliable and effective way to resolve employment disputes. In addition to the EEOC, the various state agencies dealing with human rights also have mediation programs that are somewhat effective. The federal courts also have mediation, and they vary from state to state. In New York, all 4 districts have it. Some of the districts provide it for free. Some of the other districts you were required to pay. But it is viewed as very effective. State courts have also started instituting mediation programs for employment cases. They've had mediation for non-employment, personal injury cases and things of that nature for a long time. But employment cases, I guess within the last few years, have started to make its way into the mediation in the courts. So why would anybody choose to voluntarily go to mediation? Because it is voluntary. Well, to take something from David Letterman, the top 10 reasons to use mediation to resolve employment disputes, some are very intuitive, but some are require a little thought. So first of all, parties have an equal say in the process, and they, and not the mediator, decide the terms of the settlement. There's no determination of guilt or innocence. So the self-determination is really a wonderful incentive for parties. I would actually say, though, the top number 1 reason is that it saves money. Yes, it can cost significantly less than litigation, especially once you're going to trial. It saves an immense amount of time because most mediations are completed in 1 session. And not only is the mediation itself completed faster than any litigation, if it's done early enough in the process, discovery is limited. To state the obvious, it's fair and it's neutral. It is confidential. Lawsuits are public records, and the parties can fashion a settlement which would require confidentiality. Not only is the end result of a mediation confidential if it's successful, what's said during the mediation is likewise confidential. It avoids litigation. I don't know if that requires any expansion, but with all due respect to Judge Skelos, you save the uncertainty of what a judge is going to do, and more importantly, what a jury is going to do. The parties themselves determine what is going to happen. It also fosters cooperation and a problem-solving approach to complaints of employees, especially when people are still working at an employer. It will also reduce workplace disruptions, because rather than having the employees talk about an ongoing litigation, this can get done very quickly with a lot less disruption. And again, the discovery aspect of it also reduces the disruption of the employees. It can improve communication, which when you have improved communication amongst the parties, it naturally leads to a mutually satisfying resolution. The parties can participate in a setting that's neutral and confidential, so they can openly discuss their views, which will then lead to a mutually satisfactory resolution. The parties can really find out, especially from an employer's point of view, what's really going on in the workplace, what are the real issues, and how can they make this the environment better for all the employees, not just the party that is bringing the claim. Because sometimes there may be a real underlying issue, and the open communication that a mediation provides will foster that. Everybody can allow for their own, again, as I said before, their own solution to it. So the self-determination factor is really again, something that I always stress, because the mediator, a good neutral, will assist the parties in reaching a voluntarily and a mutually beneficial resolution that everybody at the end of the day will be happy and everybody will win. And without stating the obvious, everyone walks away and there's no determination of guilt or innocence. Everybody just goes their own way with a mutually satisfactory resolution, and hopefully one where the parties have resolved their dispute. I think that really covers everything.
Thank you, Rhonda. Hold on, I just skipped 2 screens. Let me get back to this one. I think Rhonda made an excellent point, particularly about the issues of collaboration and self-determination, and that's what that's why mediation in the context of labor and employment disputes are so important, because of the ability to work with each other, find out the problems, and fashion a result. It's a lot different. You can be creative in this context. And it's different than mediation in personal injury, where it's really just about the dollars and the cents. But mediation in labor and the employment context allows you to fashion a solution to maybe the problem that brought you, or the underlying problems that brought you to the dispute. So let's move on and have a discussion about how you create an ADR program in the workplace. All right, you have to ask yourself a few questions, which you see up here on the screen. Maybe we should have put the second one first, so I'll just address that. And of course, if it's part of a collective bargaining agreement, then in that context, it's going to be very detailed. It's going to be worked out with the bargaining unit and the employer. But if there is no collective bargaining agreement, that doesn't mean that there can't be, the parties can't take the opportunity to create a company-wide ADR policy. And that's for management, of course. And if there is a collaborative atmosphere with management and labor, they can work on it together. But the question becomes, is this going to be a company-wide policy, or is this going to be a policy that is going to be applied in the context of a particular title or job classification and below or above? Those are some of the initial issues. Then, of course, once you do implement the program and create a program, the question is, how do you get it out to your employees? Should it be part of the employee handbook if you have an employee handbook? And of course, you should have there should be an employee handbook. If there's the possibility that it could be an employee-specific agreement to arbitrate, or an employee-specific agreement to mediate, there's the possibility that it could be drilled down to that level. When you do create the program, you have to ask yourself a question. Is this going to be a program where we're going to be going straight to arbitration, or is there going to be mediation as a precursor? And there may even be a program where mediation is a prerequisite to going to litigation if the ADR program does not have an arbitration component to it. Of course, it's my view that if you are going to have an ADR program and you are going to have mediation as a component of the program, and you're trying to take advantage of all of the benefits of ADR that were outlined by Rhonda, and which will be spoken to by the rest of the panel, then it seems to me that you should be having an arbitration component to your ADR program. Then you have all of the other issues that come up in creating the ADR program. You may want to just speak to the issues that are going to be subject to alternative dispute resolution and define those issues. If there are issues to be excluded, you can exclude the issues. you have to consider whether or not you're going to designate a particular agency for the purposes of ADR. And when you have the agency that's designated, you should be looking to the rules of the agency. And that's something that Jackie Silvey will speak to when we get closer to the end of the program. So it's a good idea. We at NAM, of course, think that it's a good idea for you to designate an agency in your arbitration or ADR program with your employees. And of course, to include NAM as your designated agency. And the agency can have its own rules. So here we have rules that apply to our labor and employment dispute resolution program. You can modify those rules. You can create your own rules. But those are some of the things that you should be thinking about. You should also be thinking about how you're going to be selecting the mediator or the arbitrator. Is there, do you want to leave that up to the agency administrator? Do you want to have the agency administrator give you the names of 3 neutrals to choose from? Is there veto power by one side or the other? What's the extent of that veto power? Those are matters that Jackie, I think, will be speaking to towards the end. And you should also be considering, in the context of creating an ADR program, creating language whereby you're going to be precluding the opportunity for collective or class action, which could end up costing the employer significant funds. So you should be, these are some of the considerations you should have. You can work on how you're going to create the program with your ADR provider. That can be a collaborative and a joint effort with the ADR provider. I think now we're going to switch to David. And David, I'd like you to address some of the pros and cons of using ADR in the employment context. Of course, we're going to focus on the pros, and then we'll also speak to some of the cutting-edge issues that are coming out of the coronavirus pandemic. David?
Thanks, Judge. Unfortunately, folks, I wasn't witty enough to think like Rhonda did of the top 10 list of the benefits of a workplace arbitration program. For better or for worse, though, many of the pros are the same as with mediation with a little bit of a twist. First, arbitration is well, the first 2 things are connected to each other. The arbitration is quicker. It's a quicker process than litigation. And for that reason, among others, it's also more cost-effective than litigation. It's cheaper. So there's been some recent studies, one from the Federal Mediation and Conciliation Services, that the average time from filing to a decision for arbitration is about a year to a year and 3 months. A similar case would take 18 months to 3 years to wind its way through the courts. By the way, I practice in both state and federal court here in New York, and I don't know of any case that's done in 3 years unless it's settled. We're typically looking at 4, 5, 6+ years. Another study said federal court is about twice as long from start to finish as an arbitration, and that's federal court, which is much more streamlined, obviously, than state court. So why is it quicker, and why is it more cost-effective? Well, there's a lot of reasons. I'll hit some of the more important ones. First of all, there's less motion practice. When you have an issue in arbitration, what you typically do is you contact the arbitrator. You write a letter, you attach any exhibits, you ask for a telephone conference, and the arbitrator will typically give your adversary the opportunity to respond to your letter motion, and you'll have a phone call. You're not making a 30-page motion with affidavits and exhibits and filing it and getting it adjourned over and over and over again, and then, quite frankly, waiting 6 months to a year, if not longer, for a decision. You just, again, contact the decision maker, in this case the arbitrator, and you get a phone conference. There's a more streamlined written discovery. What I typically do when I arbitrate a matter is at the outset of the matter, we have a telephone conference, and we talk about the issues. The legal counsel educates me about the case, and we discuss discovery. It's not court. You're not getting 95 interrogatories and 120 document production requests unless the case calls for it. You're not getting 10 depositions. We streamline it. We figure out what everybody needs, and we figure out a time frame as well. And so that's why it's not only quicker, but it's more cost effective. It's cheaper. There's also flexibility when it comes to arbitration. The bottom line is, at the end of the day, you, meaning the parties and their attorneys, are the consumer, and the ADR administrator, like NAM, wants to keep you happy. So we move cases along. You're not in an overcrowded court calendar. You don't have to jump through hoops to contact the court. If you need, and everyone agrees, on a weekend phone call or an evening teleconference, it's getting done. So there's flexibility in that way. You get to choose the arbitrator. Obviously, your adversary has a say in that as well, but you get to choose somebody who, in this case, would have expertise in, say, employment and labor law. You can delve even deeper into that and get an attorney who has expertise in your specific employment issue, such as the Fair Labor Standards Act or Americans with Disabilities Act. There's a lot of really bright judges out there who know a lot about different areas of law, but they may not be experts, if you will, in the area that you're seeking, that the dispute arises in. So in arbitration, you get that flexibility of being able to choose an arbitrator who has an expertise in the area. Going back to what I said earlier, there's simplified rules of evidence and procedure. Arbitration dispenses with much discovery. And let's face it, the rules of evidence in state court and federal court are often convoluted, and the civil procedure mechanisms in courts are often convoluted. And this kind of arbitration tends to cut through all that. When it comes to hearings, I know that I have a pre-hearing conference where we figure out how long we think the trial is going to be, the hearing's going to be. What witnesses are going to be called, what exhibits are going to be attempted to get into evidence. We might whittle down some of the pre-hearing disputes and issues that you find many times arise in a hearing or a trial. And so we're able to streamline the actual hearing itself. Arbitration many times is private, including testimony. It's not open to the public like court is. And so, and even the terms of any final resolution can be kept confidential. So both the privacy and the confidential aspects of an arbitration can be very important. Say, for example, if trade secrets are involved, or a company's client lists, or if some of the testimony could be embarrassing to one or both parties. I believe arbitration tends to avoid or limit unnecessary hostility. My experience in court is once a lawsuit is filed, every issue many times is fought over. And I think there's a number of reasons for that. Some of it is just that the hostilities are high. You're in court. It's costing money. Many of it is attorneys don't want to go back to their clients and say they gave in on an issue. Many times attorneys and parties know that the day of reckoning on an issue is going to be 3, 6, 9 months away, if not longer. So why give in? As opposed to arbitration, when again, many disputes can be resolved in a simple phone call. I think when the day of reckoning on that decision, whether it's a discovery dispute or something else, when the day of reckoning is in the near future, I think parties tend to work together a little bit more. So parties are encouraged to cooperate with each other in order to reach mutual agreements on matters related to the arbitration. There's also, finally, predictability and uniformity and consistency in arbitration. Arbitrations tend to avoid, or they do avoid, that runaway jury with a massive award. You're guaranteed that the parties will be treated relatively consistently and uniformly. The process will basically remain the same. The arbitrator has the ability, especially with the parties' consent, to change some aspects of the discovery process in arbitration. But for the most part, you're dealing with the administrator's rules of civil procedure and rules of evidence, and that's very handy in predicting and the consistency. You're not, when you're involved in an ADR program, you're not dealing with the civil practice rules of different states, different federal districts. You're dealing with, NAM's rules of evidence. So you have a predictability there and a uniformity that you're not going to get in court.
David,
there's some
David, let me just chime in for a minute. I'd just like to comment on a couple of items that you mentioned. So let's look at more cost-effective than litigation, faster than litigation, and flexibility. All right, I think David's absolutely correct on the flexibility issue. There's room for that here, but we as neutrals want to satisfy you. All right, we're not going to reign herd over you. All right, but if you want, for the benefit of your client or for your company, to have a more cost-effective, faster, and flexible dispute resolution process than litigation, then it's really up to you to understand that's one of the reasons why that you're coming to arbitration, and take advantage of the opportunity that this venue offers to be different and better than litigation. David?
Absolutely. So there are some potential disadvantages that I've heard of. I don't put credence in many of these, but this is what some individuals think. And the first one is potential employee resentment or backlash. There's a school of thought that says, well, you're taking something away from the employee, you're taking away the jury, you're taking away the court system, and that employees may feel, forced to do something, to go to arbitration, forced to give up their rights. And while that may hold some truth to it, I have found actually the opposite. In fact, there's another school of thought that says, well, arbitration is so easy, you might get more cases because employees feel that they can just go and run and file an arbitration. They don't even need an attorney. They'll handle it pro se. I don't think either of those are true, quite frankly. I have found, and this is just anecdotal, although I have found it from some of my own clients, that employees appreciate arbitration. Yes, I think there is some aspect that says, well, I don't get my day in court, but you do. And you're in front of an arbitrator, and it's a human being, and you're able to have either pro se or have your attorney put in evidence and get discovery, and you get to have your day in front of the arbitrator. So although some employees may feel that some resentment about having to go to arbitration if there's an arbitration program in the workplace, I don't find that to be an issue. There is some limited recourse. Typically, an arbitrator's award is final and binding on both parties, and judicial review is very limited. Section 10 of the FAA, the Federal Arbitration Act, basically has 4 grounds for vacating an award, and they're what you would think they are. They're corruption, fraud, the rights of the parties were prejudiced by the arbitrator, or the arbitrator exceeded his or her power. And the same thing in New York, we have CPLR Section 7511, same idea, corruption, fraud, or misconduct in procuring the award. So your ability to appeal, if you will, is limited. That is actually one of the pros or strengths of arbitration, is that you're not, you're not going to be hit with endless appeals of various decisions from the lower court. One of the issues that has been expressed recently is rising costs, and I don't believe this is necessarily true either, but I'm cognizant of it, as I'm sure the other arbitrators are. We as arbitrators it's a balancing act. We want to make sure that you get the information and documentation that you need as a party to this arbitration. But we have to remember that it's arbitration. And this is very tough, especially in more complex matters. And we have to make sure that we, again, streamline discovery, because that is what costs money, obviously. Every deposition is costing a fortune for everyone. Every document production request, every set of interrogatories, every motion. So arbitrations, some feel are becoming longer and more formal with more discovery allowed. I don't particularly find that. I have found when I've gone, and again, I'm a practicing attorney as well as an arbitrator and mediator for NAM, but when I'm in front of an arbitrator, and I arbitrate quite often, I have found that they do get this balancing act right. And again, that goes hand in hand with the lack of a formal evidence process. And again, the arbitrator has to make sure that they get the exchange of information and documentation just right between the parties. And so a party without overextending its rights to get documentation and information, without harassing the other party or having this all-encompassing request for documents and information and endless interrogatories and depositions, that they can still get and fine-tune their requests so that they get the information and documentation that they need. And that's one of the reasons that first conference that I spoke about earlier is so important, so that and sometimes I tell the parties that they should do a scheduling order for me, and I review it and we tweak it during that conference. So it's very important to get that right. Some feel arbitration may not be the best recourse for all disputes. I understand that, especially if you have a workplace agreement or an agreement with a particular either employee or set of employees. You're agreeing to arbitrate everything at the get-go, and so maybe a dispute arises that may not be the best recourse for arbitration. I actually can't think of one off the top of my head, so I don't particularly think that's a huge issue. And you just have to remember too, when it comes to workplace disputes, that although you can go to have a program or go to arbitration, it's not going to stop the state and federal agencies, whether it's the Equal Employment Opportunity Commission or the New York State Division of Human Rights, from coming in and investigating your company or your client. But that would be the same in a court. They reserve the right, even when you resolve cases, that in the settlement agreement it always says that the individual can go to these agencies. They can't get money or any monetary recourse, but they can go to these agencies and they can make a complaint, and the agencies can come in and investigate. So it's no different than being in court.
Hey, David. Before we get over onto the issues concerning that are arising out of the pandemic, maybe we should take a short break, and so that our listeners can get their CLE information. Absolutely.
Great, thank you so much. Let's go ahead and read out today's CLE code for this event. So the CLE code for today's event is Law 17. That's LAW and the number 17. Again, the CLE code for today's webcast is Law 17.
Okay.
Thanks, David. I'll turn it back over to you.
Okay.
Great.
So,
Thank you, Kelly.
So, David, we're going to speak a little bit to how COVID has changed the labor and employment dispute resolution process. Before we do that, I'm just going to say that here we have a terrific platform for handling, the terrific technological platform for handling mediations and arbitrations away from the courthouse. We have Zoom video conference technology, and quite honestly, I think we've had it mastered since I did my first one on March 20th, and even to the extent that it wasn't mastered at that time, we've certainly mastered it to the present. David, why don't you speak to some of the issues that are arising out of COVID?
Absolutely, Judge. So COVID-19 has completely upended the legal profession. It's upended the economy. I mean, from commercial operations, logistics, finances, across all industry sectors, individuals and businesses have been greatly affected. And this has put financial pressure on everybody. And it's changed the landscape, especially of the workplace, in ways that I believe are permanent, from remote work, less travel, streamlined technology. So it's changed everything. And unfortunately, I believe that I know it has already affected the legal landscape and increased the number and types of disputes. At the same time, unfortunately, it's affected the court system substantially. The delays and the backlog and the capacity of the court system to resolve these disputes has absolutely diminished. Now, in New York, at least, the court systems were closed for months except for essential matters, which were really emergencies. They're opening back up slowly. They're doing a fantastic job. But the bottom line is there's a huge backlog. I recently had a case where my adversary filed a note of issue a few months ago, and we had a conference with the judge, tried to settle the case and couldn't. And the judge said, I'll see you in 2022. So there is, again, a backlog, and with the quarantines, in addition, it's very difficult. And I know courts have started using phones, but it's just not efficient. I've been on court conferences, on teleconferences, where the old standing in the hallway in Kings County Supreme Court with 1,000 other attorneys, it was that, but I was on the phone. They were calling every other case, and I was number, 35 on the calendar or whatever it was. And so it's just not efficient. That's opened the door wide open to arbitration and to ADR providers like NAM. Judge Skelos was absolutely right. NAM had these procedures in place with the Zoom and the other technology, and it just really moved everything over to that remote arbitrations and mediations. So technology, NAM is, and I'm sure other ADR providers as well, they're set up for virtual hearings. So parties can arbitrate to provide that all can tailor their arbitration to provide that all hearings take place virtually through platforms and document sharing platforms like Zoom, thus ensuring physical distancing. There's paperless process, so documents can be, and the exchange of documents and evidence and written arguments can take place electronically without the need for submitting physical copies to the arbitrator or the other party. This is standard practice in most arbitrations anyway, and again, it was seamless just to move everything over to this process. Tremendous flexibility for arbitrators and the parties. We can still do arbitrations face-to-face if that's what the parties want to do. But the days of the U-shaped conference room or the conference table with the arbitrator at the head of the table and the parties on either side is gone. I mean, it's still here, but it's fading out. We can do remote hearings, obviously. We can have parties in different rooms, attorneys in different rooms. Sometimes the arbitrator may want a witness to not have a mask on, let's say, so that witness can be put in a separate room, take the mask off, so that the arbitrator can get an idea of the credibility and veracity of the witness. We can use split screens, and everyone can be in different places and exchange information seamlessly. Mediation by phone, virtual conference rooms. So technology, as far as the ADR providers, is well ahead of the court system. And you have a choice. You can either go to arbitration and move your matter along, or you could sit and wait on the long line down at the courthouse. That also goes with timeliness. This just moves things along. The parties can affix timelines and move the case along at their own pace, as opposed to going to court. When you go in the first time, you get a scheduling order. You go in a second time for the compliance conference, and that scheduling order, we all know nothing's been done. Your adversary is giving you a hard time, so this completely streamlines that. Another opportunity that I see with regard to arbitration and COVID is that arbitration can be used for only some of the aspects or portions of a dispute. For example, the parties can agree to arbitrate a motion concerning the scope of documentary discovery. So you have a case in state or federal court, but maybe you have a document discovery dispute. You can go to arbitration for just simply that issue. If there's interlocutory issues, such as injunctive relief, if there's key substantive issues, such as a statute of limitations defense, all of these, just part of the dispute that you may have pending in court, can be brought over to arbitration, and you can get a decision from an arbitrator that everyone agrees on that aspect. And it can, number one, narrow the dispute, and number two, move the case along in court. And the parties can retain the ability to return the rest of the dispute to court when the crisis lifts, or you can just keep it there and go to arbitration for that one issue. So that's certainly a way, the backlog with the court system, where COVID has had a great aspect on the legal profession.
David,
the types of claims.
David, can I just jump in for 1 second? Everything
Sure.
David was saying about arbitration and technology also holds true for mediation. I think at this point, almost everybody has participated in some type of Zoom event, so that what might have been scary to participants, 9 months ago, now isn't. So telling people that we're going to do this in Zoom and you're going to go to breakout rooms, or somehow or another we're going to share screens, I think that the skepticism and the mysticism about the technology is pretty much gone. So any reluctance that people might have had to doing these things remotely pre-COVID, I don't believe exists anymore. Not to mention the fact that not only does it save time, it saves travel time. You could have people participating all over the world, and they don't have to go through the expense of getting there. They just have to turn on their computer.
Absolutely. I think a lot of these things we're talking about are simply common sense and that we're applying to the arbitration process. All of these things were kind of going in this direction. They're now going at warp speed. So the future is now, if you will. So I've seen that COVID, and I think this is going to absolutely continue in both in the short term and the long term. COVID has caused an increase in a change in the types of claims that we're seeing, primarily an increase. One of them is breach of contract claims, and in this area, we're talking about workplace arbitration. We're seeing a huge increase in breach of employment agreement claims. Just very quick story. When this thing first hit, I can't tell you how many calls I got from my corporate clients saying, Dave, we can't afford to pay so-and-so what we're paying him. And we were fortunate enough to get in touch with the CEO, the CFO, the controller, whoever it might be, and renegotiate the employment agreement. And quite frankly, there was some choices in some of these matters where it was, hey, we can terminate you and pay you 3 months or 6 months or whatever the contract called for, or fight you over it, or we can enter into a new contract where we're reworking your compensation. So it worked out, but it didn't work out for a lot of people and a lot of companies and a lot of primarily executives. Unfortunately, and there's nothing nefarious about it. Unfortunately, well, sometimes I'm sure there is, but companies can't afford to pay what they were paying. So many companies out there reduced pay by 10%, 20% or more. Unfortunately, if compensation is set by a contract, then there might be a dispute about that. I'm seeing an increase, and I'm expecting more of an increase in wage and hour claims due to remote work, people on their cell phones, people on their laptops late at night, early in the morning. How are you keeping track of that? I'm seeing an increase in that. I'm assuming, I have not seen it myself, that there's going to be WARN matters, worker adjustment and retraining notification act matters, both federal and on the state level. Paid and unpaid sick leave laws, including the Federal Families First Coronavirus Response Act. In New York, we have the New York State Paid Leave Act. I'm assuming there's going to be an increase in those types of claims. In fact, I get too many calls. I get so many calls every day on both sides of it, because I do represent employees and employers regarding leave. And it's so complicated, and you feel for these people, but you feel for the employer as well. Everybody's trying to do their best, and they can't. I'm seeing more EEOC claims, and that's just because people are being let go, due to the economic crisis. I'm especially seeing a lot of disability discrimination and reasonable accommodation matters, and that has to do with working remotely. That has to do a lot with respiratory issues, autoimmune matters, individuals who have these health issues, and they don't they don't feel safe in the workplace, or they don't feel safe getting to work due to mass transit. And violations of collective bargaining agreements. I think there's going to be an increase in class and collective actions, especially wage and hour claims and claims pursuant to the WARN Act. I just don't see a way that that's not going to happen. One of the things, finally, that I wanted to bring up is when you do have a workplace arbitration agreement or program, you have to be careful to avoid class and collective actions if you want to, and the assumption is that you do. A recent case in May of 2020 came out from the Fifth Circuit, and it held that a company's arbitration agreement did not prevent employees from pursuing their claims as a collective arbitration rather than as individual claims. In that case, the employee had brought an overtime claim in arbitration under the Fair Labor Standards Act, pursuant to his employer's arbitration agreement, and he pursued the claim on behalf of himself and a class of similarly situated employees. The company objected and said, we don't want class actions. We thought we made it pretty clear in our arbitration agreement. The arbitrator did not agree with that and allowed the claim. It was appealed to the district court, which agreed with the arbitrator, and on appeal to the Fifth Circuit upheld the lower court decision. They did that based on two factors. First, the agreement required the employee to submit to binding arbitration for, quote, any claim that could be asserted in court or before an administrative agency, with few exceptions. The appellate panel found that the existence of certain exceptions and the lack of a class action carve-out within those exceptions suggested that the employer did not wish to prevent class claims. The agreement also incorporated the rules of the American Arbitration Association for employment disputes, which permit class arbitrations. The Fifth Circuit's decision, without getting too technical, didn't really jive with some other cases like Epic Systems Corp versus Lewis or Lamps Plus Inc. versus Varela, which basically stated that the arbitration agreement should explicitly state that the parties wanted class or collective action in an arbitration. The analysis is that the Fifth Circuit probably didn't want to overstep their bounds by overruling the arbitrator. So I read the agreement. I don't particularly agree with it. But the takeaway is that any agreement to arbitrate should explicitly state that the agreement precludes class and collective actions. So it should specifically don't leave anything to chance. So with that, I'm going to...
We're going to move on to the next topic, okay,
yes.
Which is going to be a discussion of what's inside the mind of the neutral and how to best prepare for your mediation and or arbitration. All right, and I guess the catchword of the day, as always in our legal field, is preparation. How do you prepare? And the best way to prepare really is to have a well-done mediation statement. We as mediators, as neutrals, would like to have as much information about your case as possible. We do appreciate, we want to have that information. You should provide us with a statement of the relevant facts. If there is a true legal issue in the case, you should be identifying the legal issue and having a discussion of that legal issue. Another important thing, of course, is to prepare your client. Don't just tell your client that you're coming to mediation. Explain to the client what mediation is all about. When we first started today, earlier today, I had a mediation this morning. The clients were here. We did it in person. Of course, we were wearing masks. But there came a time when the plaintiff really needed to hear from the mediator personally. Counsel for the plaintiff had let the client know that there would be an opportunity to speak with the mediator and to have an understanding. And we did have a face-to-face discussion. And I think what was important is I reiterated to the clients a lot of things that the attorney said to the client. And that ability of the neutral to reinforce the information that has been given to the client is a very important factor. You should also have an understanding and have an agreement on who needs to be present at the mediation. So if you have a position, whether you're a plaintiff or defendant, that the other side needs to have a decision maker there, not just the attorney, then you should let the other side know that you need a decision maker there. This is the last two, I think, are particularly important in the labor and employment context. And that's, first, it's really no surprises. And how are there no surprises? There should be a draft of the settlement documents. If you are representing the defendant in a labor and employment case, you should have a draft of the settlement documents, leaving, of course, the essential terms as to how the case is going to be settled out of it. But there are certain things that you know that your client, the employer, wants. There may be a need for a confidentiality clause. There may be a need for non-disparagement clause. Of course, those have to be mutual, reciprocal. You should be vetting that with the other side in advance so that they know that that's an issue that is essential to a resolution of the case. You may also have to have extended payment terms. If they're going to be extended payment terms or other specialized payment terms, those items should not be surprises, but those items should be vetted with the other side in advance. We can also speak to Rhonda or David, maybe speak to the strength, some of the other things that you can identify in preparation for your mediation or arbitration. And we'll try to move it along so that we can have enough time for Jackie to speak to her issue.
But I'll quickly jump in. And when the judge was saying about who needs to be present at a mediation, one of the other issues sometimes is sometimes if it's a sexual harassment claim or some type of harassment claim, the employee does not want the harasser present, or you have to make sure that they're going to be very separated. And that's something to really flesh out at the beginning, going to who's going to be there and no surprises. The other thing would be not only preparing your clients for what's going to happen at a mediation, but also preparing them for settlement possibilities. And, when you're preparing the case and you're identifying the strengths and weaknesses of your case and the strengths and weaknesses of the other case, you have to be realistic, because sometimes we're such advocates for our clients that you don't see the other side. And then when it's presented, it's very difficult for your client, be it the employer or the employee, to accept that. So at least there has to be some type of, I think, intellectual honesty going into it, so that people are more ready to hear what the other side has to say, and to know the different things that can come out that will affect the negotiation. Sometimes a document will come out that you've never seen before, and you have to be prepared for that there can be things that happen at a mediation that you did not otherwise know, because if there hasn't been discovery, you won't know until you're right there in the room. And if people are so set in what they expect the outcome to be, it's very difficult to persuade people without any warning. So I think part of the preparation is knowing these are our strengths, these are our weaknesses, this is what we think the other side's strengths and weaknesses are. But there's always the possibility that we're going to learn something new, and we have to be prepared to move forward. And from the mediator's perspective, I like when people are as honest as they can be with me, with the strengths and weaknesses of their case, because it helps me fashion a settlement for everybody.
All right. Thank you, Rhonda. Jackie, maybe you could help us out here and speak to some of the issues in working with the ADR administrator.
Sure. Thank you, Judge. So NAM's the designated administrator of many national, state, and regional employment programs across a wide variety of industries. So I've seen a lot of different contract provisions and programs over the years, and I thought I might share some of this with you, so anyone contemplating whether you are creating a program or modifying your existing program, you might want to just take some of these points into consideration as you approach what you want to provide for. One of the most important important decisions in the process is the process and the procedure that you're going to implement, and that includes the decision to provide for arbitration in lieu of litigation in court, but it can also include, as we previously said, requiring mediation as a precondition to the arbitration. The bottom line is that at some point you need to provide the process for the filing of the claim, the rules and procedures that will apply to move the case through to a final decision, and an established ADR company has sets of rules that are often case-type specific that will provide the process, the rules, and the procedures to be followed. Now, sometimes an employer will choose to write their own rules, and many times I see a hybrid, which is an internal word that I like to use, but it's basically where the employer is choosing to incorporate certain items in the employment contract and program and then adopt the rules and procedures of an ADR provider for the remaining issues that are not otherwise specified in the contract or the program. However it is that you choose, the most important thing is the more specific the contract program, the less chance there is for some dispute regarding the process as you move it along. Some of the considerations have already been discussed. I'm just going to quickly go through them. How many arbitrators do you want to make the decision? You can specify one arbitrator to be appointed, or you can ask for a tri-panel. How do you select the panel? For example, NAM's rules provide for a panel of 7 with very specific instructions on how to strike and then rank your preferential arbitrators accordingly. But I've also seen an employer provide for a choice of 9 arbitrators, then you do an alternate strike and it's the last one standing. And I've also seen somebody say 3 arbitrators and you each strike one and then that's the last person standing. So that's a consideration that you could put into your program and agreement. Discovery, I think we've discussed, quite a bit today. It's often addressed by the ADR provider in their rules, but you can again put certain limitations into your program and contract. The location of the arbitration is important, and many times it is generally where the employee works or last worked for the company. And that's generally to provide a more fair and convenient location for the employee as opposed to the business. Who will pay for the mediation or the arbitration? Most of the time, the employer is paying the majority, if not all of the fees. We talked briefly about the right of an appeal, and yes, while arbitration is final and binding, I've seen a program or a clause provide for a right to an appeal to a tri-panel within the arbitration setting, so that's an option. And I also see we're out of time, so I don't know if you want how to choose your administrator. I'm just going to quickly jump ahead. Look at the rules, look at the fees, look at their level of case managers and the ability of those case managers to really assist. A lot of times we have pro se's, non-represented individuals that need help to file and get through the process, and the more experienced your ADR provider is and the more experienced that your case managers are, that really helps a lot. And one of the other things is the experience and the reputation, not only of the administrator, but of their neutrals. If you're creating a program, you want to know that those neutrals can hear cases either throughout the country or in specific states, and you really want to look at the panel. And I'm going to just stop early because I think we're out of time.
Excellent. Thanks so much, Jackie. Lots of great information to pack in there. And thanks so much, Judge Skelos, Rhonda, and David. This has been a great discussion. Lots of valuable insight. Thanks also to Law.com for their support and to everyone in the audience for making the time to join us. We hope this discussion was useful to you. Just as a reminder, all participants will receive an email shortly with detailed instructions on how to receive your CLE when it becomes available on September 24th. You will also receive an email 1 week from today with instructions on downloading your state-specific CLE certificate. And if you missed any part of this presentation or would simply like to view it again, it will be archived shortly at law.com/webcast. And while you're there on that page, also feel free to explore other upcoming and on-demand presentations. Thanks, everyone, again, and have a wonderful afternoon.